Linda Anderson of Anderson Elder Law, and I just want to talk to those of you who are named as an agent under General Durable Power of Attorney. The first thing to understand is that under the law of agency, your role is to step into the principal's shoes. So an example of this is perhaps an adult child who's been paying the bills for a parent who may have cognitive decline. And the idea is to make sure that you're always assuming the responsibilities with the protection of the document that explains to everyone who's a third party that you are in fact an agent and not an additional party to a contract or a responsible party. You're actually designated as the agent. It's important to understand that every state is going to have requirements as to what belongs in the power of attorney, and Pennsylvania is no different. Under our law, there has to be a specific notice in capital letters that includes certain paragraphs, otherwise the power of attorney is not going to be presumed to be a valid power of attorney. The other thing to understand is that a power of attorney with elder law enhancements is going to include all kinds of references to the techniques that may be needed to proactively or reactively deal with significant long-term care expenses. So sometimes there are carefully planned gifts that are authorized under the document, or the creation of trusts, or the idea of taking care of other special needs beneficiaries. But the idea is that the content in the power of attorney really matters. We do not have a statutory form that would say what every document must say. So it's important to make sure that your power of attorney is not a template and not based on something that somebody else might have had, but actually reflects the careful decision making of who is going to be responsible, but also gives them the scope of authority they're going to need to handle not just administrative things, but really serious financial transactions. When does your authority end? Well, when the person passes away, the agent no longer has any legal responsibility or authority to conduct financial matters. And so it may be possible, if someone doesn't know about the principal passing away, that they may do things and they won't be held liable. However, once you actually know that the principal has passed away, you should no longer conduct any business as an agent under the financial power of attorney. It's important to recognize that this document protects not only the principal with carefully drafted instructions, but also the agent, so that when that person steps into that role, you are making sure that perhaps other siblings or other family members who may not feel exactly as you and your agent feel get the protection of a document to make sure that they're not potentially personally liable for things that you've asked them to do. If you need more information, I encourage you to call our office.